last one.
So my name is Caitlin Patterson Gagnon, and I am the Community Outreach Coordinator for Good Life Programs and Activities. I just want to say thank you to Seth from Greenblott and O'Rourke for being with us here today, and to Greenblott and O'Rourke and Arcadia Financial for being our partners of the month for April. So I will hand it over to Seth, and you guys can get going.
Thank you so much, Caitlin.
Mm-hmm.
I'm the host now, guys. I'm in charge. It's dangerous.
You're welcome.
Thanks. Take care.
Bye.
So thank you everybody for being here. You'll have to bear with me. This is the first time I've done this Zoom presentation. I've had thousands of meetings over the course of the last year, but we haven't tried to do one of these Zoom webinars, which we normally do live. So I'm thrilled with the turnout that we've had here, and we'll figure this out. Typically, I do this in a very informal style. I want you to sort of jump up and down and ask questions anytime that you have questions. We'll do our best to make that work via Zoom because I think that's how people get the most out of these presentations. As Caitlin said, my name's Seth Greenblott. I'm a partner at Greenblott and O'Rourke. We're a 6-attorney law firm. General practice, we do everything from felony level criminal matters to real estate transactions, civil litigation, estate planning, corporate work. My personal practice is primarily corporate work and estate planning. We have 3 other attorneys that work with me on our estate planning, 2 that do sort of generalized estate planning, and 1 that does asset protection, tax planning, Medicaid planning type of estate planning work, which we'll talk about a little bit. Our partners for this month for the sponsorship is Arcadia Financial. Unfortunately, Mike Bianco, who is the owner of Arcadia, was sick today, so he's not joining us. But they're a wonderful financial planning institution. Their main office is in Manchester, New Hampshire. We work closely with them on a number of clients. And so if you are, as you're thinking about your estate planning needs, thinking about your retirement and financial planning needs is an important aspect of that. Thinking about life insurance and that sort of thing sort of goes part and parcel with thinking about how we're going to set up your estate. So whether it's with Arcadia or some other financial planner, I always encourage people to start thinking about putting together a full team when they're working with us. And that team, should be someone to talk about your finances, someone to talk about your insurance needs, preferably a CPA, talk about different tax and accounting needs, and us. So Mike and his team are often part of that big picture that of people that we work with clients. My goal today is to give you an overview of your different options with estate planning. We're not going to get too into depth on any one thing. I want you to walk out of this Zoom conference and be able to go talk to an attorney, whether it's our office or someone else, and know where to start the conversation. And so instead of starting at the very basics, you can start talking about your family, your life, your wishes, and hopefully we get you a little bit ahead of the game. You're going to know some better questions to ask at those one-on-one meetings. That's our goal here today. I don't know what everyone's experience level is. Some of this may be redundant. If it is, I apologize. For some people, this may be brand new information. So we're going to start at the very beginning. Do jump in if you have questions. I ask in the meantime if everyone would mute their microphone. And if you have questions, feel free to unmute and start yelling at me until I figure out who's yelling at me. So the basic documents we're talking about when we're talking about estate planning for most people are either a will or a trust. And generally when we're talking about trusts, we're talking about what are called revocable or lifetime trusts. You may hear inter vivos trusts. Those all mean the same thing. Essentially, they're a trust document you create while you are alive. You're in control of the assets in it. You can change it or get rid of it at will. So that's generally the trust instrument that we're talking about for the vast majority of people. And the other option for estate planning, general estate planning, is a will. A will is the simplest method of disposing of your assets after you pass away, making sure that they get to the right people and in the right way. A will goes through the probate process. That's a number one misconception I think I have from people coming into my office is that they think if they have a will, they don't need to go through probate. But a will does get probated. And what that process looks like is someone passes away, their executor, the person that's named in that will to take care of their estate, administer their estate, will file a petition for administration with the probate court, typically in whatever county the person passed in, but not always. And that petition for administration will say, I am the executor. This person has passed. Here's a copy of their death certificate. Here's a copy of their last will and testament. Please open up an estate and formally appoint me as the executor so I can start taking care of this person's financial estate. When once someone is appointed as the executor, they will begin paying bills, collecting income, liquidating assets, etc., pursuant to the provisions of the will. All this is done under the supervision of the court. There are some fairly strict inventory requirements, that is sort of telling the court what is in the estate, giving an estimate of its value, and then very stringent accounting requirements at the end of the estate to say, this is the money that went in, this is the money that went out. Here's why, here is compensation that was paid to the executor, to different professionals. Now that we're done court, please let me divide this up and give it to the heirs pursuant to the will. That process generally takes at least 6 months, is the sort of short end requirement of keeping the estate open. And unfortunately, that process can go on, and I've seen it take years, but generally you're looking at sort of 6 months to a year is a fairly typical time frame.
But I think she did.
I'm sorry, somebody is unmuted in the background. I don't think they're asking a question. That's all right. I think if everyone goes down in the bottom left-hand corner of their screen, there should be a little microphone icon. And if you click on that, that'll mute your microphone.
It's muted. Oh.
And I think actually I can, because I am the host, I can mute everybody. So let me just do that for anyone. All right, I think I have muted everybody. If you try to unmute yourself and you can't, you can send me a message or start shaking your hand around and I'll see it. All right, I think we have everyone muted here. So that probate process, as I said, 6 months to a year is not in a typical length for that process. Many people get through that process without an attorney and without too much headache. I would say 80 to 90% of the people navigate that process. And it can be a bit of a pain, but it is not a nightmare for them. 10% of people end up with pretty serious issues. And those issues often will come from family members that disagree about what is happening, take issue with how the executor is doing something, take issue with how things were left in the will, or there is some sort of complicated asset that is going to be a challenge to get through the probate process, or simply the executor maybe wasn't the right person to do this, and it's something that they're struggling with. And for that, 10-ish% of people, probate can really be a hassle. The way that we avoid probate is through a trust. And there are some other mechanisms that we can avoid probate for specific assets that are identify a beneficiary on them. So a pay on death bank account, brokerage accounts, typically you'll be able to identify a beneficiary, life insurance, your home for married couples if you're joint tenants. Those type of things don't go to probate and avoid probate just by the nature of the asset. For everything else, though, you end up in the probate court, and that process is on the positive end slow at the very least, and can be problematic depending on your individual circumstances. So for everyone, one of the reasons we talk about doing a trust is to avoid probate. Makes the process much faster. It's a cheaper process generally once you pass, although it is more expensive to set up the trust in the first instance than setting up just a simple will. And it often, although not always, avoids some of the conflicts that you see in probate court. Because you're already in court, and because the beneficiaries are being notified of sort of everything that occurs, there's less barriers to people causing problems formally in the court process. And so I think it's often true that you will see more conflict through the probate process than you will see through an estate that's being administered through a trust. The trust also allows us a lot more flexibility than a will. So with a will, essentially all that we can do is say, here are my assets, please give them to these people. in this percentages or in this manner. And that's the end of it. You sort of divide up your estate and you give it out as you've set forth in your will. With a trust, we can do a lot more. We can manage how things are used for people, how they're divided, how they're invested, all kinds of different things that we can do with a trust that will sort of continue on after you pass. With a will, you really can't be in control of your assets after you pass. I have a question. Excellent. Someone working on the chat. So the question here is asking if you have a trust, or am I saying that you don't need a will? Generally, we end up doing both. So if someone has a trust, we do what's called a pour over will. And that is a will that says, if there were any assets that would go through the probate process, that please put them into my trust for me now that I've passed away. And we do that sort of for a couple different reasons, but one is a backstop. In the event that someone forgets to put an asset into their trust, it's called funding their trust, to retitle something into the name of the trust so that it's owned by the trust and will avoid probate. We put this will in place, this pour over will, as a backstop so that we don't end up going through probate for a single bank account or something like that. In that instance, you do open an estate with the probate court. You file the will, you file a petition, but then you file for what's called summary administration. And that says to the court, the only beneficiary here is a trust. We don't need all this court supervision. We don't need to do these formal accountings. Please let us do this outside of the court. And the court grants that in almost every circumstance. So it's a backstop. If you do end up in probate with it, it makes the probate process much faster and much easier. And so we generally produce both. The other reason that we do it is statutorily, someone has, in most circumstances, 6 months to bring a claim against the estate if they're a creditor and the estate owes them money, if the deceased person owed money. And that 6-month period of time to bring that claim starts with the filing of the will. And so we like to get that will filed and have a will to file so that we start that 6-month clock for creditors to bring claims. Another question here asking if the executor can also be an heir. It absolutely can. And often that is the case. Often we will have a child or a spouse serving as the executor and as the beneficiary, or heir. Heir and beneficiary mean the same thing. So that is not only allowed, but I would say more often than not that's true. So for my office, I think probably 80 or 90% of the estate plans that we do will have some sort of trust involved in them. And that percentage is sort of increased over the years. I would say 5 years ago, it was closer to 50-50, and trusts have just become more and more popular. I think people are more and more comfortable with them. More of their friends and neighbors have them. And so it's more commonly what we do. I don't push people hard into trusts unless, just to avoid probate. It's a good reason to do a trust. Don't get me wrong. I would do a trust personally just to avoid probate. But that's really a sort of a personal decision of, do you want to spend the extra money now, the extra effort now that it goes into setting up the trust? Or are you comfortable with that happening sort of later on after you're gone with your executor and your heirs through the probate process? And there's really no right or wrong answer to that. That's a personal preference. So if it's just probate avoidance, I'm certainly happy to do a trust. I would encourage people to do trust, but I'm not going to push you too hard in that direction. Where we really start pushing people for trust is when we start looking at your individual family circumstances. So where trusts really shine and become an instrument that is really valuable are for blended families, for example, and where you have shared assets with a second marriage, you have children from prior relationships, and you're trying to figure out how do we care for one another, and then also make sure that our assets go to our respective children, perhaps. That's something that's much easier to do with a trust than it is with a will, and much better accomplished with a trust. So if people have children or other heirs or beneficiaries that are suffer from mental health issues or substance abuse issues, or simply someone that you don't feel comfortable giving a chunk of money and saying, go with God, I hope everything works out. We can address those issues through a trust. It's very challenging to do anything through a will with to address those type of issues. So it's really comes down to your individual family circumstances. I spend a lot more time talking about your family dynamics, getting to understand if your kids like one another, getting to understand how you and your spouse maybe commingle funds or don't, than I do talking about how many dollars you have in the bank. I need to have a rough idea of your financial picture, a rough idea of how your assets are held, because once in a while that will change what we're suggesting. But it really comes down to family dynamics. Let's see, jump here. Let's see. Another question. So the question is, if there's only one heir and all assets are going to that heir, is there really a benefit to the trust other than avoiding probate? And I would say it just really depends on that heir and the assets. So one of the other reasons that we may strongly suggest you think about a trust is if you hold assets outside of New Hampshire. Every place that you hold assets, there will need to be a probate estate. So if you have a second home in Florida, you will not only be probating up in New Hampshire, but you'll be probating down in Florida as well. That becomes much more complicated and much more expensive. The probate process in New Hampshire is relatively inexpensive. Some other states have compensation schemes set up for executors and for the attorneys that get involved in those that are, we'll just call them very generous for the attorneys and the executors. And so you can end up spending a lot of money on the estate administration, depending on what state you might be in. Florida is one of those states, New York's another one of those states. And then there's also estate tax issues that need to be considered depending on where those assets are held. New Hampshire has no estate tax, but other states do. Depending on the nature of the assets in that state, those are things to consider. And so there's no just clear, bright line answer to that question about I only have one heir, do I need a trust? Depending on the circumstances, it may be very prudent to have a trust, or it may be fine not to have one. And those are the type of conversations that we would need to get in on an individual basis. The other thing that's nice about a trust is that it is a sort of private affair, right? There's nothing that's taking place in the court generally, unless there is, something goes wrong. It is occurring outside of the public arena. And so for some people, that's really important. They don't want, a court record of their estate, and the sort of anonymity that's provided by a trust is really important to them. And sometimes it's important because they don't want the wider world to know their business. And sometimes it's important because they maybe want one beneficiary to not know what the other beneficiary is receiving, for example. And that's much more challenging to do in an estate, probate estate context, but very easily accomplished with a trust. The other benefit of a trust, again, is can be tax avoidance, depending on where you are located. So our Massachusetts clients, for example, are often pushing towards trusts because of the estate tax that exists in Massachusetts, and we can do a lot to shield money from Massachusetts state taxes through trust mechanisms, and we can't do it with a will. And so it's a more expensive proposition to create those kind of trusts, but the savings for your estate is, tenfold depending on your what worth. So those are the reasons we start pushing people towards a trust. I apologize. The other reason is if you have some sort of unique asset or want some asset managed into the future. So if people have, let's say, a lake house or a camp that's been in the family for generations and they want to preserve that for generations more, trusts are often part of how we accomplish that. Sometimes we use business entities as well to do that, but we often talk about a trust option for those type of assets. Or if you have a going business concern, sometimes we talk about holding that business interest in a trust so that it can be managed by a professional and generate income for someone in the family that may not have the ability or interest in running that business. And that may be other, investment opportunities as well that you may hold, that it's worth getting a professional involved. That is another nice benefit of a trust is it can be managed long-term by a professional where that's appropriate. Obviously there's a cost associated with that. Generally that cost is about 1% of the total value of the trust annually. That's sort of the going market rate for that, although it does vary. The only guidance that the state gives us is that it has to be reasonable compensation. We don't have a lot of guidance from our Supreme Court about what that means in New Hampshire. So it has sort of evolved that typically means 1%, similar to what you would pay a financial advisor that's managing your assets. So obviously that can become expensive if you have a financial advisor managing the assets of the trust and a paid professional trustee. You could be, 2% in plus paying for CPAs and everything else. So there are times when that's absolutely appropriate and money very well spent. But we try and find other solutions for our clients if we can, so that we don't end up eating up the value of the estate with administrative costs. So those are the benefits of the sort of general revocable trust. And a lot of people have sort of a difficulty conceiving of what a trust is. I always say that the best way to think about it is it's a contract between you and yourself. So it's a contract that you draft as the grantor, that's the person putting assets into the trust, and the trustee, the person that's going to manage those assets in the first instance, that says, here's what I'm putting in, here's how I want it managed now and in the future. And if anyone else comes in, here's the contractual terms about how I want you to manage it in the future. And that's really all it is. It's just a contract that says this is how my stuff is to be taken care of. And it doesn't, a revocable trust doesn't really change your life. There is not a significant difference as far as how you file your taxes. There is not a, you got to get used often to having the trust name on your checking account. But other than that, there's really no difference to how you conduct your personal financial business. It's really a very user-friendly instrument for estate planning for a lot of people. There are a lot of specialty kinds of trusts that we get into depending on someone's circumstances and what we're trying to accomplish. Irrevocable trusts, for example, are trusts that we set up that, as the name implies, can't be revoked and are much more difficult to change, much more difficult to pull money out of. And often the reason we do that is for asset protection purposes, whether it's a tax purpose or more often for Medicaid planning. But the downside to that is that you, especially in New Hampshire, have to really give up control and the benefit of the underlying asset in order to accomplish that tax savings or that Medicaid planning, to not have that asset counted for Medicaid purposes. So often people come into our office and that's something that's primarily on their mind and that they want to do. And once we get into the details of what that really looks like and the sort of the downsides of that, most people choose not to move forward with that. It is a challenge to do asset protection in a way that doesn't dramatically interfere with your financial picture and your sort of financial life, and is robust enough to sort of stand up to the scrutiny of the state coming through and saying, does this really shield assets? Is this all kosher? And New Hampshire is particularly challenging to do that because of some of the case law that we have on how Medicaid assets are counted. There are circumstances where it is absolutely appropriate, and we will strongly encourage clients to do it. But it really, that's a very individualized conversation, and one we're happy to have, but we want to really talk about what your assets are, what you're trying to accomplish, why you're concerned about your assets being utilized for your end-of-life care, long-term care. Those are lengthier conversations to have and pretty detailed. And often my clients need to go back and think about things several times before they commit to doing that. And I would encourage people to do that because it's a commitment to set up some of these instruments for those purposes. And it's also a pretty significant expense. Any questions on trust as a general proposition? You guys are easy. You normally have a much hotter bench than this. I think it's Zoom. So the other documents we're typically working on when we're doing these packages are your advance directives. So these are going to be your financial power of attorney, your healthcare power of attorney, living wills. Sometimes we create guardian documentships for people. Guardianship documents rather for people. And those documents are all documents that are in effect while you are alive and generally are addressing issues of incapacity. So for your healthcare documents, they are appointing someone to make healthcare decisions for you in the event that you're unable to do it for yourself. And they're giving direction to that person and your medical providers about what your wishes are in that circumstance. The other document, the financial power of attorney, allows someone to step in and act in your place for financial matters while you're alive. Those can be set up several different ways. They can be set up so that someone can do it at any time, and they can be set up so that it only happens in the event that you're deemed incapacitated and can't do it for yourself. That power of attorney is only in place while you're alive, and it only would pertain to assets that aren't inside of a trust. If assets inside the trust are actually going to be managed by your successor trustee, the person that you appoint after yourself to manage the trust assets, that person would step up in the event that you became incapacitated and sort of serve in that role for any assets that are in the trust. But the power of attorney becomes important even with the trust because there are certain assets that we often don't put into a trust for various reasons. So individuals' retirement accounts, for example, as the title implies, have to be owned by an individual. And so those assets, we need a power of attorney in place so that someone can act in your place in the event that you can't, to manage those accounts for you. And then there's sometimes other things that we leave out of a trust for a variety of individualized reasons. Whether a trustee or a financial power of attorney, that person, one you need to trust, obviously, because you're giving them a lot of power while you're still here to control your assets. Certainly your executor has a lot of power, but you're gone at that point. And so while it would be unfortunate to see someone misappropriate your funds, it's not the same as someone doing it while you're alive and leaving you destitute or financially challenged while you're still living. That is, choosing that person is a really important choice to make. And it's also important for that person to know and understand the responsibility that comes with serving in that role, and that there are a lot of rules that go along with serving in that role. That person needs to pick up the phone and call an attorney in the event that they're acting in that place for you, or that you're acting in that place for someone else. If they want to do anything that is just not very clearly, signing a check and paying a bill on your behalf. There are some new laws that came out in 2017, I believe. Might be a little later than 2017 or 2019. In any event, that created new criminal penalties for people that misappropriate funds as a financial power of attorney or as a trustee for someone that is elderly or disabled. And there are people that are running afoul of those laws sort of accidentally, doing things that they think generally their parent would have signed off on, approved of, been okay with. But there is sort of no paper trail showing that would be okay and approved of, and technically they're violating the law. There have been prosecutions and people have been serving pretty significant sentences for things that I think a lot of people do, unfortunately, and people are doing without bad intentions. So it's really important if you're in that role, or that you're, whoever you may assign to serve in that role for you, that they understand the gravity of that and the responsibility that comes with being in charge of someone else's money, and that they really do have to act in all instances in your interests, and make sure that their money and your money stay separate, and all of those type of things. But it was sort of a big change in elder care and how families operate financially at the end of someone's life, or when they get older and just aren't able to do it for themselves. And I unfortunately don't think enough people are aware of how serious those things can be. So I like to make that clear during these presentations. I do have a question here again about deferred comp IRAs. So generally those IRAs can't be owned by the trust, but the trust can be identified as a beneficiary of it. And so that just means that when someone passes, the payout will go to the trust, but the trust, the actual asset, the IRA, isn't owned in the name of the trust. There was a recent change. The Secures Act was passed that changed a little bit of how that the rules around IRAs and how the deferred payout goes and the required annual deductions and how those can get carried on to different heirs. So that's changed recently, and that's probably a topic for an entire presentation in and of itself. But it's something that we talk about. So depending on how much of your assets are held in an IRA or some account like that, can influence how we draft your trusts, or if we choose to do a trust in the first place. Any other questions? Can't believe
Could
that
you
no
go
one has.
back to the revocable trust?
Yes, absolutely.
Maybe say, give us some examples of the times, not for extraordinary people, but for regular people, that you might use it.
Sure. So, you know, for everyone, it keeps you out of probate court. And so that's a benefit for everyone.
No, they're irrevocable.
Oh, irrevocable. Sure. So
Kind of fled through that one.
yeah, so the irrevocable trust is generally designed to take property out of your name or out of someone else's name, and provide as much benefit as we are able to from that asset without crossing the line where the state will say you have control and ownership of that asset. And that is either, it's generally to protect it from creditors or from the government in one form or another. And we're to some degree, we're impoverishing you on paper. And New Hampshire is one of the states that says, well, it has to be more than on paper. It has to sort of be for real. If you have any meaningful benefit or control over that asset, New Hampshire, as a general proposition, says it's still yours, and it's either still accessible by a creditor or it still counts for purposes of counting assets for Medicaid. So, you know, one of the things that we often get asked for is to put people's homes into irrevocable trusts to preserve that asset against Medicaid claims. In New Hampshire, that is really difficult to do because if you live there, if you have any control over it or gaining other benefits from it, the state is inclined to count that even if it's in an irrevocable trust. And that is just sort of a state by state thing. It's easier to accomplish in Massachusetts, for example, than it is in New Hampshire. It's not impossible, and there are circumstances where we do that. Generally, we do that where someone is, let's say, I'm going to just make up some numbers here, but let's say someone owns a $250,000 house and they have $250,000 in cash, cash equivalents. And for whatever reason, we know that they are going to need to go into long-term care, and they're likely to be there for a long time, and their assets are likely to be eaten up, and they're going into long-term care pretty soon. Well, we can take their house and put it into an irrevocable trust and really deprive them of all of the benefit of that house. And as long as we have enough look back period before the state needs to look towards that house as an asset, it's going to be 5 years. And so we need 5 years before they need to look to that house as an asset. Generally, we can protect that house asset for their heirs. It's not protecting it for them. They've lost control of that asset, but we can preserve it for their beneficiaries to inherit. So that's generally what we're talking about. There are not these sort of loopholes where you get to keep and live in your house, but through some technicality, it's not yours anymore, and so the government doesn't look at it as your asset. It's not that simple, unfortunately. But there are circumstances where it makes a lot of sense. It's all about preserving for sort of the next generation or a spouse or something like that to inherit that asset. But generally, we're turning over control of that asset to that generation or that spouse. And spouse is a little different than next generation. I always tell people with when you're talking about asset planning, there's no silver bullet. There are pluses and minuses, and often people find that the minuses outweigh the pluses, but not always.
I have one other question. What about having your son or daughter who you want to inherit a piece of land? Mm-hmm. What about having them co-own it with you?
Sure. So co-ownership won't protect your ownership interests from being assessed by the state or a creditor or whatever, but it does avoid probate, and that's generally what people are trying to do. Is they put their kid on the deed with the right of inheritance, And that keeps that property out of probate. And a lot of people do that. A lot of people do that successfully. It's a really cheap way of staying out of probate, certainly cheaper than drafting a trust. But it comes with downsides. So the downside is that your child truly owns that property, or at least owns a joint interest in that property. And so just like your creditors can get at it, their creditors can get at it as well. And, sometimes what we see is that and I unfortunately have seen this, in real life, where a parent does that, and then the kid gets divorced, and suddenly their spouse is now making a claim against the parent's home. And while there is homestead protection if something is your primary resident, your child is probably not living there and doesn't enjoy the same homestead protection. Same thing is true. It takes bankruptcy options off the table because there's no bankruptcy exemption for a second home or property that you don't occupy. And so that's the danger there, is you are giving that's the danger, assuming your kid doesn't do anything intentionally wrong. But that something could go wrong financially or in a relationship, and someone could have a claim through your child against your property. But a lot of people do it, and again, a lot of people do it without any issues. But when there are issues, it's an issue. It's very ugly and challenging to sort of unwind. I have a question about nursing home long-term care insurance. So yeah, that's a great question, and I often will suggest, before we do something like an irrevocable trust or one of those kind of more complex instruments, that someone sit down and have a long conversation with a skilled financial planner and a skilled insurance broker, because they often find that they can fund their own care in a way that is, or a lot of their own care in a way that is better than tying up their assets and doing some of these funky things that may or may not work depending on the timing of everything and the rules of the game. It's the government doesn't like that lawyers are trying to figure out all these ways to shield people's assets. The government wants to get paid. My strong suspicion is that they're going to continue to close these loopholes that we're finding, because these programs need to get paid. They're all financially strapped, and with the checks that the government has written over the last year here, I suspect the government is going to be asking for more money back from people, not less. So we could spend a lot of money and go through a lot of effort, and then 5-10 years from now, all of that is for nothing and can be hard to undo. So again, I always give that caution to people. And so talking to a financial planner and an insurance broker who can discuss long-term care and long-term care options, as well as some other instruments that they have that I don't have. For example, there's things called Medicaid annuities that work to convert assets into income, and Medicaid looks at that differently. And so you can preserve some assets, preserve an income stream for yourself or a spouse, and still have the state step in and pick up your end of life long-term care needs. And those are just, in my mind, generally better tools. They all, again, come with pluses and minuses, but it's usually a combination of things, right? If you have certain number of dollars in the bank, maybe you have a pension, or you have Social Security, or you have retirement accounts, and you can sort of look at those and say, all right, I can self-fund long-term care this amount a month for this many years, and still make sure that my children receive something, or my spouse has enough to live on. And then, okay, well, that's what I can fund. Here's what it costs on average, right? It's $6,000 to $10,000 a month, depending on the type of place that you're at. And the average stay, I think, is about 2.5 years. So that gives you a rough idea of what you need to plan on. And so I can afford this much of that, and I have to close that gap. And often that's where long-term care insurance becomes valuable. Long-term care insurance is extremely expensive if you're looking to fund $10,000 a month for 2.5 years. It's much less expensive if you're looking to close a gap of $1,500 a month for 2.5 years. So again, it's often looking at your full financial picture. And that's why I like people to, if they don't have their own financial planner, we have Mike and a number of others that we work with that we'll try and get people in front of, because they can help flesh out all of your different options and all the different tools that we have available to address these different concerns people have. Sometimes I'm the best option. Sometimes the complicated, expensive trusts are absolutely the thing we should be doing. But more often than not, there is a better option for people. Joe. Good to see you, Joe, by the way.
Good to see you, Seth. We've got a will that's probably 35 years old, 35 years old. And of course, as I recall, I haven't seen it in a long time, but as I recall, should something happen to me on the way home tonight, I get killed in a car accident, all of my assets and everything would transfer over to my wife. She would be 100% beneficiary. If we were both traveling and we both got killed, then it gets into the executor of the estate and everything like that. But the will still has to be, if something were to happen to me alone, the will would still need to be filed in court. So she would be able to take over all the assets, correct?
That's correct. I mean, often with spouses, there are very few assets that have to go through the probate process. You know, not everyone, but many couples will, you know, everyone's name is on every bank account. They're both on the deed to the home. They're both, you know, named as beneficiaries on the IRA. And so a lot of that stuff doesn't end up going to probate. So a lot of times when we're talking about avoiding probate, we're really more concerned about the next level of inheritance. And so, you know, children or other heirs that come after a spouse. That said, usually there's still, you know, a handful of assets that need to go through the probate process for a spouse, but typically it's relatively minimal. And thankfully, New Hampshire did a couple of things that recently that were helpful. So you can transfer 2 vehicles, I believe, just by going down to the town clerk's office with a death certificate between spouses without going to probate court. You know, it used to be we would sometimes do trust, and the only thing we would put them in is vehicles, because who wanted to go through that, you know, probate just to get the family car over to the other spouse. But that's become much easier now. So again, we're often talking about the next generation when we're talking about really the value of the trust coming in.
Okay, good, thanks.
But you're correct. Generally, if there are any probate assets, you know, any non-direct inheritance assets, they would have to go through probate.
Okay, thanks.
Sorry. I'm sorry. If you will done with another firm, could we still go to you to? Oh, absolutely. Yeah. I mean, look, I reviewed. So someone's asking if they've already done their will with another firm. Can they come to us to do trust and have these other conversations? Of course. I review people's documents all the time. I typically don't charge to review them unless there's something really unusual. And a lot of times I'll review people's documents and just say, hey, these were well done by a lawyer that knew what they were doing, and you don't need to do anything unless you're changing your mind about something. And once in a while I'll see something that, you know, I don't like. And once in a while I see a document drafted by an attorney that was very badly done. It's fortunately rare, but it does happen once in a while. So yeah, if you just want someone to take a look at it, feel free to give us a call, have a consultation, discuss what your options are, things that I might suggest to consider that maybe you haven't had conversations with before. That's great. We do that all of the time. And again, there's sort of no charge to that unless you end up hiring us to do something. And you know, as far as Medicaid annuities and financial planners, yeah, I mean, I make referrals all the time for people that are clients and not clients. I generally, we have different financial planners we work with that all have sort of unique skill sets and tend to focus on different demographics of people. And so, you know, if I get to know you a little bit, I may say, hey, you're going to be great. You know, Mike Bianco is going to be your guy all day long. You're going to love working with him. And some people he's not, and we'll connect you with somebody else. And Mike does the same thing. I'm not the only attorney he works with. And, you know, it's about personalities and skill sets and needs for the client. So we all have a network of people that we work with. And my goal is to just make sure you get into the right hands. And that's how we've built our business, is getting people the right help that they need. And at the end of the day, whether I'd rather make money on you well into the future because we sent you to the right person, even if it wasn't us, then, you know, make a couple dollars on you today and not be the right guy for you. So that's our general philosophy. Pick up the phone and we'll make sure you have the right people working for you. Any other questions? Any questions about healthcare, power of attorney, living wills, any of that type of stuff?
I was in a workshop recently and it was an addendum for dementia.
Mm-hmm.
Could you say some, because that's like, that would be my worst fear.
Sure. Yeah. So there, and that document is, you know, fairly complex in and of itself, but it's the living will and your healthcare power of attorney generally deal with these sort of end of life circumstances when you're very near death or you're in a permanent coma. And the dementia addendum is where maybe you're not very near death, but you are very, very ill with dementia, and deals with, you know, what do you want to have happen in that circumstances as far as receiving nutrition and hydration, medication, medical intervention. And it goes through a lot of different options for you to be able to convey what you would want to have happen in that circumstance. And so generally it talks about things like, do you want to receive hydration and nutrition intravenously? Yes or no? Again, there's no right answers to these questions. These are extraordinarily personal choices to make. I can do my best to walk you through, you know, my understanding and experience with doctors and clients that have been in that circumstance. But I don't think anyone has, no two circumstances are the same when you're dealing with those kind of health situations. And so it really comes down to your personal, religious, philosophical, spiritual beliefs. And we'll do our best to help guide your thought process there. But that's a client decision. And then, you know, the other options are, I want to only be fed in that circumstance. For example, if I can, you know, eat normally, if I can pick up a sandwich and eat it, then keep putting sandwiches in front of me. And if I can't, then, you know, please don't have someone feed me in that circumstances. Certainly don't feed me intravenously. Those are all options for people to pick. And some people know exactly what they want to do, and some people we have 3 meetings to just talk about it until they sort of come to a conclusion of what's appropriate for them. You know, a lot of times husbands and wives will have different answers, or one will decide they don't care or don't want to think about it, and so they just pick what the other one picks. You know, again, very personal circumstances, but that's generally what we're talking about. It's a end of life, well, not end of life. It's a very severe level of dementia, and what do you want your healthcare to look like in that circumstance?
And is that something people always fill out, or
we generally include that in our sort of packet of documents, but if someone that doesn't want to do that for whatever reason, then you know, we can exclude that. And often what we'll do is we'll produce it and give it to them, and they can take it home and fill it out in the future if they choose not to do it. Most people will include that document and you know, complete it along with their other documents.
And my one other question was what kind of advice you give for drawing down reverse mortgages? How does that fit in all of this?
I don't give any advice on that. I'll just be frank that that's not an area of where I have enough knowledge. I have just enough knowledge to give you bad advice on reverse mortgages. So I try not to do that. But again, it's something that we can bring people in and get you in touch with people that can help give you better advice about that, and what that looks like. It really comes down, again, all these, there is no right or wrong answer about them. They're all about your personal financial picture. And that's where we bring in people like Arcadia to help discuss that, and bring in accountants, or we have a tax attorney on our staff that can come in and sort of say, you know, here's the implications of what you're doing. But I am not the one to give you advice on reverse mortgages.
I just think sometimes people get offered bad deals.
Oh, I think that's true. And I think, unfortunately, people get sales pitches that are wrapped up in to appear like advice often with those kind of things. And that's not to say that reverse mortgages aren't great tools for certain people. I think they are. But I don't think that they're the right tool for everybody. Just like anything else that I do. There are times that a revocable trust is absolutely what you want to do. There are times where it's nice, but who cares? and everything in between. And we try to guide you in the right way as best we can. But I think more and more people have had experience, as people's parents' generation is aging and passing, and just the change in demographics in our country. More and more people are having contact with probate court, or whether it's firsthand or secondhand, and are interested in avoiding that process. And so we often find that people that we might not otherwise push towards a trust still want to do a trust just for that reason. Anything else I can answer for anybody?
So I'd always been told that best planning, you might still end up in probate because you hadn't signed the title on your car.
Yeah, that can happen. So
But
that's one of the reasons
your
we
pour over will would do.
correct.
So
And
that's-
a vehicle is no longer an issue. Well, if one or two vehicles is no longer an issue. But yeah, you could, if you had that 1969 Corvette and you forgot to sign that over, and yeah, we could be probating one asset. It happens. But the pour over will makes that at least a very easy, straightforward process. I'm gonna back up and say it's intended to make that an easy, straightforward practice. Unfortunately, there are no guarantees in my business, but we're doing our part in that circumstance to make it an easy, straightforward process. I have someone asking me a question on the 5 wishes document, and I'm gonna just be frank that I've never heard that term before. So if someone wants to give me an education today, I'll appreciate that. Who's asking about the 5 wishes?
Hi,
Hi.
I'm Bobby. I'm sorry I came late. I had another Zoom that ran over.
Don't be sorry. Welcome.
The 5 wishes document has been around a long time. I think it started Florida,
Okay.
but a lot of other states recognize it, and it has a lot more. I don't know. It's similar to the advanced directives, but a lot more. I don't know, easy to understand. It's layman's terms.
I gotcha. Sure.
And so I was told recently, if you just mention it in the advanced directives document that we have, that we want this included, maybe New Hampshire will recognize it. Do you know anything about that?
Sure. So, well, the advanced directives, the healthcare advanced directive, there's a statutory form that is more or less required by the state. We have some wiggle room in it, but that does leave there is an ability to add to it under a section that's called special instructions. And so I'm gonna have to go do some research here myself. Again, I've never heard that term, and but likely we could add whatever those directions are into the special instructions portion of the advanced directives and accomplish a lot of the same goals.
Okay,
But I will point out that with the healthcare advanced directives in New Hampshire, what you're doing and what the language says is you're authorizing your healthcare agent to make certain decisions. It is impossible to bind them in New Hampshire in that kind of way. And I think that actually makes a great deal of sense from a policy perspective. That is, and now you could end up in court and get a court order that your wishes would be different, and there is a process to do that if it were necessary, and someone felt that your healthcare agent was not acting in your interests and carrying out your wishes. But absent a court order, that's the mechanism of compelling somebody to do that. Otherwise, you're giving them authority to act one way or the other. So yeah, I think probably the answer, without knowing exactly what these 5 wishes document is that we can likely accomplish a lot of the same things by adding it in and drafting it into the advanced directive. But I can't promise you that without a further understanding of what the specifics of that document are.
So were you just saying that the agent that you appoint actually has the final say, even over what you have it written in your document?
Sure. So it works this way. So if you authorize someone to discontinue medical treatment in a certain circumstance, for example, they can choose not to do that based on circumstances on the ground in their judgment. They can't do the opposite though. If you say, I don't authorize you to discontinue medical treatment, they can't make the decision to pull the plug on you. And so just the way that it's drafted, you can't compel them to pull the plug absent a court order, but you can compel them not to pull the plug, if that makes sense.
And can that person who's the durable power of attorney for healthcare, that person, can they also be a beneficiary or an heir to your items, or a power of attorney for finances?
Yes, they
Is there
can.
any conflict at all when you have them do everything?
I don't know if there is sort of a conflict in their own mind, but there is no sort of legal prohibitive conflict there.
Okay,
So that is perfectly fine for them to serve in both roles.
great. Thank you.
No problem. And thanks for giving me some homework. Anybody else? Let's see. Looks like Carol and Merwin have a question here. You guys unmute yourself there. You're still muted there, Carol. It's in the bottom left-hand corner of your screen. There you go.
What if someone has a relatively small amount of money and would like to set and doesn't have to worry about heirs, and would like to leave some money that would continue on in support of some venue, some body in, not, you know, not physical body, some corporate body.
Yeah, you want to support a charity or something of that
Yeah.
nature.
And you know, if I would like to leave something to provide cat food for, that's not going to happen. I just want
Sure. No, yeah, I understand. I have drafted trusts to support cats before though, so I just it can happen. Yeah.
My daughter keeps talking about my funding the feral cat sanctuary. That's a great joke in our house. But what if someone wanted to do something like that? How would you do that?
Yeah. So it depends. There's a couple of different mechanisms that we could do. So the first and probably easiest is that you just identify that entity in your will and say, this is who I would like my estate to go to. And then they would get that, whatever assets you left to them. And you can leave all of your assets, you can leave a percentage, you can leave specific assets. And you can also do it, sort of conditionally say that, in the event that I still have bank account ending in these 4 numbers located at this financial institution, I want that asset to go to this charity. And then in the event that you need that money while you're alive and there's no more money there, that's fine. So, we can do it through a will. You can do the same thing through a trust and say, I want to make sure that this money goes to this charity. And then depending on how much money there is, you could set up a charitable trust, either a separate charitable trust or a sub trust within your trust that's a charitable end, to manage that money, invest it, and then give certain amounts to the specific charity or in support of a sort of a charitable mission. And so you could do that through a trust mechanism to maintain that money and manage it and invest it and distribute it, long after you've passed. So that's possible as well. So it sort of really depends on how much we're talking about and what you want that to look like. But there's a lot of options that range from the pretty simple to the pretty complex.
To have it go to a good cause rather.
Yeah, sure. And I've done that too in wills where someone doesn't have a specific charity in mind and they just say, I leave it to my executor to divide this among, whatever charities and how many ever charities they find prudent and believe would be, in keeping with my wishes and interests. So we can just leave it very much up to your executor as well, or your trustee.
Thanks.
Anything else here, folks?
I have a question.
Yes.
And just in terms of, I get about it, I thank you for the understanding I now have about probate and wills and that I guess I didn't understand about that process of probate. But in the terms of a trust, it sounds like to avoid that process of probate, even if you minimally don't have a lot of assets, let's say it's a house and maybe, you know, $400,000 or $500,000 or whatever. Is there a way to kind of judge? I know each circumstance is different, but is there a way to kind of get an idea cost-wise, the cost of setting up a trust? And then is there a yearly cost with that as well until
Sure.
the trust becomes, I don't know, however that works after you pass away?
Yeah. So only because this is going to be recorded, I normally I would just tell people our prices because we do everything on a flat fee basis and we don't hide that. But this is going to be recorded, and 10 years from now, I suspect my prices may be different. So we do things on a flat fee basis. What will happen in our office is we sit down, we'll have 1, 2, 3 consults, you know, usually after the third, sometimes I have to talk about, you know, I need to start charging you for meeting again here. But not always, to figure out what you want to do. And then once we decide what we're going to do, then I'm able to give you a flat fee price on, okay, here are the documents we're going to draft, and here's what the cost is for doing that. So you'll know before we put pen to paper what it's going to cost you. I think most law firms do, a lot of law firms do estate planning on a flat fee basis. It's a fair way of doing it. The clients seem to like it better. We generally, I think we're fairly in the middle of the pack as far as prices. There are people that are far more expensive. There are people that are cheaper. There are a few really good people that are cheaper, but most of the people that are cheaper, I don't think are
So
that
it's
great.
really based on like the number of assets and.
No, it's based on complexity. So it really is, you know, are we talking about asset protection? You know, you're probably talking $5,000+. Are we talking just probate avoidance? You know, maybe some specific assets we want to manage. You're talking probably, you know, under $3,500.
Okay, all right, that's helpful.
Yeah, I think that it's really about the issues we're trying to address.
Okay, thank you.
So Seth, I have a quick question, kind of following up on that. If I had a trust that was drafted by another attorney, but for various reasons, some changes need to be made, and I don't want to go back to that attorney,